Welcome to the 32nd meeting in 2024 of the Delegated Powers and Law Reform Committee. We've received apologies today from Ros McCall, MSP. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. The first item of business is to decide whether to take item 6 in private. Is the committee content to take this item in private?
Yes.
Under agenda item number 2, the committee is considering an instrument subject to the affirmative procedure. No points have been raised on the draft regulated roles, prohibitions and requirements, Scotland Regulations 2024. Is the committee content with this instrument? Yes. Under agenda item number 3, we're considering instruments subject to the negative procedure. Issues have been raised on 3 of the instruments, all of which underpin the implementation of the Disclosure Scotland Act 2020, which reforms the disclosure regime in Scotland. The first instrument is SSI 2024-313, the protection of vulnerable groups, referrals by Chief Constable, prescribed information, Scotland Regulations 2024. This instrument prescribes the information which the Chief Constable must refer, if held, to Scottish ministers in relation to an individual whom the Chief Constable considers is, or has been, carrying out a type of regulated role which, not participating in the protection of vulnerable group scheme, in the protecting vulnerable group scheme in relation to that type of regulated role. In correspondence with the Scottish Government, published alongside the papers for this meeting, the committee asked a question about paragraph 6 of the schedule, which states details of the person for whom the Chief Constable considers that the individual is or has been carrying out a regulated role during the relevant period. The committee queried whether the term details is sufficiently clear to identify what information must be passed on to the ministers under this paragraph. The committee notes that during the passage of the bill, it was suggested that this information would be similar to that already required for scheme members, which is limited to the gender and NI number of the individual. The committee also notes that details could include any number of pieces of information held by the Chief Constable about someone who is not the individual concerned and has no other limits or criteria applying to it. What details and how much detail will be passed is not obvious from the instrument itself, and the Scottish Government has noted that guidance will be issued in respect of the exercise of this power. Accordingly, whilst the Scottish Government considers it sufficiently clear, the committee considers that it would be clearer what details will encompass. Does the committee wish to draw this instrument to the attention of the Parliament on reporting ground H, which is the former meaning could be clearer, as the meaning of the term details in paragraph 6 of the schedule could be clearer? Yes. And the second and third instruments in which issues have been raised are SSI 2024-314, the protection of vulnerable groups, information for listing and vetting, Scotland Regulations 2024, and SSI 2024-315, the Level 1 and Level 2 disclosure information, Scotland Regulations 2024. SSI 2024-314 makes detailed provision in relation to every relevant matter and that may be used for listing purposes, and in relation to vetting information which may be included on a scheme record in respect of scheme members under the Protection of Vulnerable Groups, Scotland Act 2007. SSI 2024-315 makes detailed provision about what information will be included in Level 1 and Level 2 disclosures when the new scheme under the Disclosure Scotland Act 2020 enters into force. In correspondence with the Scottish Government, the committee queried whether the provisions in these instruments are intended to prescribe non-disclosable convictions, and in relation to SSI 2024-314, all spent cautions. The Scottish Government advised that this is not the intention and that the legal effect is correct, given the definitions in the Parent Acts. While the committee appreciates that the instruments achieve the policy intention as a matter of law, the committee considers that it could have been made clear, for example in the accompanying documents, that not all convictions and cautions are prescribed. Does the committee wish to draw these instruments to the attention of the Parliament on the general reporting ground on the basis that it would have been helpful, in the interest of accessibility, if the accompanying documents made clear that not all convictions, and in relation to SSI 2024-314 cautions, are prescribed? Yes. Yeah. Also, under this agenda item, no points have been raised on SSIs 292, 295, 316, 317, 324, 326, 327 and 330. Is the committee content with these instruments?
Yes.
In relation to SSI 2024-295, does the committee wish to draw to the attention of the Lead Committee, the Criminal Justice Committee, the committee's correspondence with the Scottish Government in relation to paragraph 1 of the schedule of this instrument?
Yes.
And welcome that this instrument fulfils a commitment made by the Scottish Government to correct an error in a date inserted by SSI 2024-26. Under agenda item number 4, we're considering an instrument not subject to any parliamentary procedure. No points have been raised on SSI 2024-323. Is the committee content with this instrument?
Yes.
Under agenda item number 5, we're considering the Judicial Factors Scotland Bill at stage 2. I ask members to refer to their copy of the bill, the marshalled list of amendments and the groupings of amendments. We were joined this morning by the Minister for Victims and Community Safety, Siobhan Brown, MSP, and 3 Scottish Government officials. Welcome to the committee. I can remind the Minister's officials that they can't participate in any Stage 2 proceedings, but they can communicate with the Minister directly. We have 42 amendments to consider and dispose of for the bill, and if votes are required today, I will call for members to vote yes first, and then call for members to vote no, and then for any abstentions. Members should do so by raising their hand. Our clerks will collate the vote and pass them to me and read out and confirm the result. And I'll take stage 2 slowly so that we have time to manage the process properly. So we'll now move on to the marshalled list. So I'll call amendment number 1 in the name of the Minister, grouped with amendments as shown in the groupings. I ask the Minister to move amendment number 1 and speak to all the amendments in the group.
Thank you. Good morning, Convener, and good morning, colleagues. Convener, Section 1.2 of the Bill requires the applicant to intimate an application under Section 1.1 to every person who, so far as the applicant is able to ascertain after reasonable inquiry, has an interest in the estate. In its written evidence, the Faculty of Advocates queried why there was no such requirement in relation to the appointment of a judicial factor in the course of other proceedings under Section 1.3. We took the view that such requirements was not imposed in relation to 1.3 appointments because the relevant persons would already be parties to proceedings, but on reflection, it seems possible that this may not always be the case. Therefore, I consider that it is sensible that the requirement to intimate to persons with an interest applies to Section 1.3 appointments as well. And this is what Amendment 1 provides for. Amendments 2, 23 and 28 confer discretion on the Court to dispense with intimation requirements in Sections 1, 28 and 31 of the Bill, in line with the suggestion by the Faculty of Advocates in its written evidence. These amendments recognise that it may not always be possible for intimation to be made to all relevant persons. For example, where the appointment of a judicial factor to the estate of a missing person is sought, the missing person will have an interest in the proceedings, but the intimation to them will generally not be possible. These amendments ensure that the Court can dispense with intimation where the particular circumstances of the case warrant this. Moving on, Convener, there was a range of discussion at Stage 1 focused on circumstances where the property to be managed by a judicial factory belongs to a charity. After consulting with stakeholders and considering the evidence, I have brought forward a number of amendments that ensure that the Bill better caters to cases involving charity property. Amendments 4, 19 and 20 in my name respond to the concerns raised by some stakeholders by recognising the difficulties that may arise where the Bill requires intimation of documents to every person with an interest in the estate, while also recognising the wider public interest in charities. The amendments require where the estate is that of a charity, in addition to the standard requirement to intimate to persons with an interest in the estate. Intimation is also to be given to Oscar as a charity regulator, and notification is to be given to the general public by the way of an advertisement. Amendment 4 also confers a power on the court to dispense with notification requirements to the public where circumstances justify this. Turning to amendment number 18 under section 26 of the bill, a judicial factor appointed on the trust estate can apply to the accountant for authorisation to exercise a function that may be at odds with the terms of purposes of the trust. In addition to applying to the accountant, the judicial factor must also comply with certain notification requirements. In line with the approach taken in other amendments, Amendment 18 provides flexibility in circumstances where intimation cannot be reasonably made. This may include circumstances where there is a wide class of beneficiaries named in a trust deed or where some beneficiaries are not yet born. Amendment 21 is in recognition of the fact that it may not always be possible for a judicial factor to intimate a proposed scheme of distribution of the estate to all interested persons. This may be where an interested person's present whereabouts are unknown and cannot with reasonable inquiry be ascertained. The accountant may dispense with intimation if, in her view, there is a good reason to do so in particular circumstances of the case. Convener, I move Amendment 1 in my name, and I ask members to support my other amendments in this group.
Thank you, Minister. I ask colleagues any questions, any points? Okay, thank you. Minister, would you like to wind up?
Thank you. I'm fine.
Okay, thank you. So the question is that Amendment 1 be agreed to. Are we all agreed?
Yes.
And I call Amendment 2 in the name of the Minister, already debated with Amendment 1. And ask the Minister to move formally.
Moved.
Thank you. And the question is Amendment 2 be agreed to. Are we all agreed?
Yes.
I call Amendment number 3 in the name of the Minister, grouped with Amendment 39. Ask the Minister to move Amendment 3 and speak to both amendments in the group.
Thank you, Convener. Section 15B of the bill contains rules as to when a particular sheriff court has jurisdiction, where the application relates to the estate of a person other than the individual, such as a company. The sheriff court of a sheriffdom in which the person has a place of business has jurisdiction. In its written evidence, the Centre for Scots Law at the University of Aberdeen suggested that a non-natural person's registered office should be included as an additional category, and I consider that this is a sensible suggestion, given that a registered office can generally be relied on to establish jurisdiction in certain actions in relation to companies. So Amendment number 3 makes this change. Moving on to Amendment number 39, makes clear that the Sheriff Court and the Court of Session have concurrent jurisdiction to hear applications for the appointment of a judicial factor, irrespective of the value of the estate in question. The Faculty of Advocates has highlighted in its written evidence that the bill did not expressly address the question of jurisdiction of the Sheriff Court under Section 39 of the Courts Reform Scotland Act 2014, and I agree that it would be helpful for the bill to make the position clear. Convener, I move Amendments 3 and 39 in my name.
Thank you, Minister. Colleagues, any questions? No? Okay, thank you. Minister, would you like to wind up?
Thank you. Just move, Convener.
Okay. So, the question is Amendment 3 be agreed to. Are we all agreed?
Yes.
And the question is that Section 1 be agreed to. Are we all agreed?
Yes.
And I call Amendment number 4 in the name of the Minister, already debated with Amendment number 1. Ask the Minister to move formally.
Move formally, Convener.
Thank you. And the question is Amendment number 4 be agreed to. Are we all agreed?
Yes.
The question is that Sections 2 to 5 be agreed. Are we all agreed?
Yes.
And move on to Amendment number 5 in the name of the Minister, grouped with Amendment number 24. Ask the Minister to move Amendment 5 and speak to both amendments in the group.
Thank you, Convener. Specific timescales are imposed in Section 6 and 29, requiring the clerk or the accountant to register a notice of appointment or certificate of termination, recall and discharge within 7 days. These time limits were put in place to ensure that registration is carried out promptly rather than to prevent registration out with that 7-day window. However, having considered the written evidence of the Sheriffs and Summary Sheriffs Association, I think there is some potential for doubt which could lead to litigation. Given that these are procedurally important steps, it is important to ensure that the clerk of the court and the accountant are not prevented from registering the notices or certificates where this is done out with the period of 7 days. Accordingly, Amendments 5 and 24 remove these time limits from Section 6 and 29, and importantly, these sections would still require the clerk of the court and the accountant to send the notices or certificates for registration as soon as reasonably practical. Convener, I move Amendments 5 and 24 in my name.
Okay, thank you, Minister. Colleagues, any questions? Thank you. So, I ask the Minister to wind up.
I just move. Thank you, Convener.
Okay, thank you. So the question is that Amendment number 5 be agreed to. Are we all agreed?
Yes.
Yeah. I call Amendment number 6 in the name of the Minister, grouped with Amendments 7, 9, 10 and 13. I ask the Minister to move Amendment number 6 and speak to all the amendments in the group.
Thank you, Convener. In its written evidence, the Faculty of Advocates suggested that where the requirement to find cation is imposed by the court, the appointment of the judicial factor and vesting of the estate and standard powers in the judicial factor should be postponed until after cation is found. I consider that this is sensible and that registration of the appointment and vesting of the estate and standard powers do not take place until the accountant has confirmed that the requirement to find cation has been satisfied. This is what Amendments 6, 7, 9, 10 and 13 provide for. This also ties in with Section 8.3 of the Bill, which ensures that where court requires cation to be found, the judicial factor does not receive a certified copy of the interlocutor and thus is not able to deal with the property until the accountant confirms that the requirements to find cation has been satisfied. I move Amendment 6, Convener, and I ask members to support the other amendments in this group.
Okay, thank you, Minister. Colleagues, any questions? No. Okay, thank you. So, Minister, would you like to wind up?
Just move. Thank you,
Okay,
Convener.
thank you. The question is Amendment number 6 be agreed to. Are we all agreed?
Yes.
I call Amendment number 7 in the name of the Minister, already debated with Amendment number 6. I ask the Minister to move formally.
Move, Convener.
Thank you. The question is Amendment 7 be agreed to. Are we all agreed?
Yes.
The question is that Section 6 be agreed to. Are we all agreed?
Yes.
Move on to Amendment number 8 in the name of the Minister in a group on its own. I ask the Minister to move and speak to Amendment number 8.
Thank you, Convener. In its Stage 1 report, the committee considered registration of notices of appointment of judicial factors in the Register of Inhibitions under Section 6 of the Bill and the alternative of creating a standalone register of judicial factories. Amendment 8 gives effect to the committee's recommendation that the bill should require the Scottish ministers to periodically review the continuing appropriateness of registration of appointments of judicial factors in the Register of Inhibitions, as well as enable Scottish ministers to give effect to any findings of such reviews. Any regulations brought under this provision would be subject to the affirmative procedure. Convener, I move Amendment number 8.
Okay, thank you, Minister. Colleagues, any comments? No. Minister, I'm sure that on behalf of all the colleagues, we're delighted that this amendment has been made. Also bear in mind it was a recommendation from the committee Stage 1 report. Yeah. Minister, would you like to wind up?
No, just move. Thank you, Convener.
Thank you. The question is Amendment 8 be agreed to. Are we all agreed?
Yes.
Call Amendment number 9 in the name of the Minister, already debated with Amendment number 6. Ask the Minister to move formally.
Move, Convener.
Thank you. And the question is Amendment number 9 be agreed to. Are we all agreed?
Yes.
I call Amendment number 10 in the name of the Minister, already debated with Amendment number 6. I ask the Minister to move formally.
Move, Convener.
Thank you. And the question is that amendment number 10 be agreed to. Are we all agreed?
Yes.
The question is that section 7 be agreed to. Are we all agreed?
Yes.
And the question is that section 8 be agreed to. Are we all agreed?
Yes.
We move on to amendment number 11 in the name of the Minister in a group on its own. Ask the Minister to move and speak to amendment number 11.
Thank you. Section 9(5) of the bill allows the accountant of court to fix a different rate of remuneration for a particular interim judicial factor. It is written evident, in its written evidence, the Faculty of Advocates queried why this discretion is restricted to interim judicial factors only and not applied to the permanent judicial factors. The policy behind Section 9 is to provide flexibility for the fixing of rates of remuneration to allow for variations in particular circumstances or where unusual duties were imposed upon a particular judicial factor. Having considered the faculty's evidence, I agree that the discretion conferred by the bill in this respect should be extended to permanent judicial factors, and this is what Amendment 11 provides for. Convener, I move Amendment 11.
Thank you, Minister. Colleagues, any questions?
No.
No, thank you. Minister, would you like to wind up?
No, just move. Thank you, Convener.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed?
Yes.
The question is that Section 9 be agreed to. Are we all agreed?
Yes.
We move on to Amendment number 12 in the name of the Minister in the group on its own. Ask the Minister to move and speak to Amendment number 12.
Thank you, Convener. Early this year, I responded to the committee's Stage 1 report setting out my views on bringing forward a specific amendment to make clear that it is competent to appoint a judicial factor over the estate of a missing person. During the Stage 1 debate, however, it was really clear that this was one of the issues that many MSPs felt really strongly about. I've listened to those views and I've considered whether more can be done to balance those views with the wider policy regarding the circumstances in which an appointment of a judicial factor can be sought. The committee's recommendation is clear that a reference to missing people could be added to the bill in such a way that it makes clear that this piece of legislation may be used by those seeking to manage the estate of a missing person. The committee will know my concerns about amending Section 3 of the bill. However, I do think that my amendment number 12 meets the recommendation while also ensuring that the wider policy in the bill is not undermined. The amendment imposes a requirement on the Scottish ministers to produce guidance about the appointment of a judicial factor under Section 1 of the bill to the estates of missing people, and as such makes clear that the families of missing persons can indeed use this piece of legislation. And Convener, I move amendment number 12.
Thank you, Minister. Colleagues, any questions, points? No, okay, thank you. Minister, just once again, obviously, this, as you indicated, this was something that the committee was felt very strongly about. So I'm sure that the amendment will actually be welcomed by certainly all of us in the committee. So with that, would you like to wind up, Minister?
No, just move. Thank you, Convener.
Thank you. And the question is that amendment number 12 be agreed to. Are we all agreed?
Yes.
Thank you. I call amendment 13 in the name of the Minister, already debated with amendment number 6. Ask the Minister to move formally.
Move, Convener.
Thank you. The question is that amendment 13 be agreed to. Are we all agreed?
Yes.
I call amendment number 14 in the name of the Minister, grouped with amendments as shown in the groupings. I ask the Minister to move amendment 14 and speak to all the amendments in the group.
Finally, Convener, we come on to discuss minor and technical amendments. Amendments 14 and 15 are technical amendments that address a point raised by the Centre for Scots Law at the University of Aberdeen in its written evidence. Section 10(7) of the bill defines factory functions for the purposes of Section 10 and Section 11, but there is no reference to the factory functions as such in Section 11. Rather, Section 11 makes reference to standard powers and functions set out in Sections 12 to 19, both of which fall within the definition of factory functions. Both of these amendments just make minor adjustments to correct this. Moving on, the way that financial assets have been defined in section 13.4 of the bill was raised as an issue by the Centre of Scots Law and the Law Society of Scotland, and in particular the Law Society's concern was about the practical effect of trying to decide whether a particular financial asset was of similar nature to cash accounts or share certificates. Given that the definition was found to be unhelpful, I have brought forward amendment number 17 to leave the term financial assets undefined. The effect of this is that these words will now be given their ordinary natural meaning. Section 33 allows for termination of a judicial factory where there are insufficient funds to meet the expenses of A, formulation by the judicial factor of a scheme for distribution of the estate, or B, the seeking of approval of such a scheme, and C, distribution of the factory estate in accordance with such a scheme. In written evidence, it was queried whether subsection 1 should have or instead of and between paragraphs B and C. The issue is whether section 33 should only apply where all three conditions are satisfied, and whether it should also apply when only 2 or 3 of the conditions are met. It is considered that there may be circumstances where, for example, there are sufficient funds to formulate a scheme but insufficient funds to seek approval and to distribute the estate. As such, I think there is value in having greater flexibility, with section 33 covering a wider range of circumstances, so amendment 30 adjusts section 33 accordingly. Coming on to discuss amendment number 31, the committee asked me to consider whether the relationship between sections 34 to 38 of the bill needs to be further clarified. I've given this some further thought, and while I don't think any further is needed on the face of the bill to clarify the relationship between the two provisions, I consider that section 34 can be usefully amended to make it clearer to users of the legislation that it is not only any criminal liability incurred by the judicial factor in the course of their actings as judicial factor that continues after discharge, but also any civil liability connected to the relevant acts or omissions. And Amendment 31 makes this change. Moving to section 43, this allows persons with an interest in the factory estate to inspect and obtain copies of certain documents relating to the factory, and these documents are listed in subsection 4. The Law Society has highlighted that the inventory is not specified in subsection 4, and that this differs from the SLC drafting, which refers to the inventory management plan, annual accounts and the audit report as being open to inspection. The inventory was unintentionally omitted from the bill when it was introduced, and amendment number 37 corrects this. It also adds the balance sheet, which requires to be prepared where a replacement judicial factor is appointed to the list of documents available for inspection. Convener, the word section is repeated in section 45(2)(a), and amendment number 38 just corrects this error. Finally, Convener, amendments 40, 41 and 42 make consequential amendments to the Bankruptcy Scotland Act 2016 following written evidence from the Centre for Scots Law, and I move Amendment 14 and the other amendments in this group, and I would ask members to support them.
Okay, thank you, Minister. Colleagues, any questions? Okay, thank you. Minister, would you like to wind up?
Just move, thank you, Convener.
Thank you. So the question is amendment number 14 be agreed to. Are we all agreed? Yes. I call amendment 15 in the name of the Minister, already debated with amendment number 14. Ask the Minister to move formally.
Move, Convener.
The question is that Amendment 15 be agreed to. Are we all agreed?
Yes.
The question is that Section 10 be agreed to. Are we all agreed?
Yes.
The question is that Schedule 1 be agreed to. Are we all agreed?
Yes.
The question is that Section 11 be agreed to. Are we all agreed?
Yes.
Move on to Amendment number 16 in the name of the Minister, grouped with Amendment 36. I ask the Minister to move Amendment 16 and speak to both amendments in the group.
Thank you, Convener. Sections 12 and 39 of the bill confer powers on judicial factors and the accountant respectively respectfully, to request information in relation to factory estates from persons and bodies. This might include, for example, requests being made to banks for financial information relating to an estate. During stage 1, some stakeholders expressed concern regarding the provisions in sections 12.7 and 39.6 of the bill, which set out that these sections do not authorise disclosures that contravene data protection legislation. These concerns were echoed by the committee, with the committee recommending that the Scottish Government consider clarifying these provisions further on the face of the bill or removing them. In light of these concerns, I've given some further consideration to the provisions and brought forward Amendments 16 and 36. These amendments adjust sections 12.7 and 39.6 to provide further clarification on the interplay with data protection legislation. They make clear that where the holder of information is considering whether a disclosure would contravene data protection legislation, they must take the provisions in the bill which authorise or require disclosure into account. And, Convener, I move Amendments 16 and 36 in my name.
Thank you, Minister. Colleagues, any questions? No. Thank you. Minister would like to wind up.
Happy to move, Convener.
Thank you. So the question is that Amendment 16 be agreed to. Are we all agreed?
Yes.
The question is that Section 12 be agreed to. Are we all agreed?
Yes.
I call Amendment 17 in the name of the Minister, already debated with Amendment number 14. Ask the Minister to move formally.
Move, Convener.
The question is that Amendment 17 be agreed to. Are we all agreed?
Yes.
The question is that Section 13 be agreed to. Are we all agreed?
Yes.
The question is that Sections 14 to 25 be agreed to. Are we all agreed?
Yes.
I call Amendment 18 in the name of the Minister, already debated with Amendment number 1. Ask the Minister to move formally.
Move, Convener.
The question is that Amendment 18 be agreed to. Are we all agreed?
Yes.
The question is that Section 26 be agreed to. Are we all agreed?
Yes.
I call Amendments 19, 20 and 21, all in the name of the Minister and all previously debated with Amendment number 1. I invite the Minister to move Amendments 19 to 21 en bloc.
Move, Convener, en bloc.
Does any member object to a single question be put on Amendments 19 to 21? The question is that Amendments 19 to 21 are agreed to. Are we all agreed?
Yes.
I call Amendments 22 in the name of the Minister in a group on its own. I ask the Minister to move and speak to Amendment number 22.
Thank you, Convener. Section 27 makes provision in relation to the formulation of a scheme for distribution of the factory estate by a judicial factor. Where a person with an interest lodges an objection to the scheme prepared by a judicial factor, the accountant is required to refer the objection to the court. Under Section 27.9, the court's options are either to reject the objection and order distribution in line with the scheme prepared by the judicial factor, or instruct the judicial factor to distribute the estate as the court thinks fit. The Sheriff and Summary Sheriffs Association suggested that a further option should be available to the court, namely to make such other order as a court considers appropriate. While it is anticipated that in most cases the court will order distribution of the estate, I consider that there may be circumstances where other orders, such as a continuation of the judicial factory, may be appropriate. So Amendment 22 adds further flexibility to Section 27, allowing the court to respond to the particular circumstances of a case. And I move Amendment number 22.
Thank you, Minister. Colleagues, any questions? Minister would like to wind up.
Happy to move, Convener.
Thank you. So the question is that Amendment number 22 be agreed to. Are we all agreed?
Yes.
The question is that Section 27 be agreed to. Are we all agreed?
Yes.
I call Amendment 23 in the name of the Minister, already debated with Amendment number 1. I ask the Minister to move formally.
Move, Convener.
The question is that Amendment 23 be agreed to. Are we all agreed?
Yes.
And the question is that Section 28 be agreed to. Are we all agreed?
Yes.
I call Amendment 24 in the name of the Minister, already debated with Amendment number 5. I ask the Minister to move formally.
Move, Convener.
The question is that Amendment 24 be agreed to. Are we all agreed?
Yes.
And the question is that Section 29 be agreed to. Are we all agreed?
Yes.
I call Amendment 25 in the name of the Minister, grouped with Amendments 26, 27 and 29. Ask the Minister to move Amendment number 25 and speak to all the amendments in the group.
Thank you, Convener. Section 30 requires the accountant to apply for the appointment of a replacement judicial factor where the original factor dies or ceases to perform duties, and the accountant considers that the purpose for which the original factor was appointed still exists and that no application for replacement has been lodged by anyone else. Having considered this provision further, however, the bill does not set out what should happen where the original factor dies or ceases to perform their duties, and the purpose for which they were appointed no longer exists, but some actings are still required to bring the judicial factory to an end. I consider that in such circumstances, the judicial factory should be formally terminated following the processes under the bill, and where appropriate, the original factor discharged. While this is not likely to be a common occurrence, Amendment number 25 is a sensible precaution to ensure that judicial factories are brought to a proper end and to avoid any doubts that may arise in such cases. Amendments 26, 27 and 29 are all consequential amendments to reflect this addition of the new subsection, and I move Amendments 25, 26, 27 and 29.
Thank you, Minister. Colleagues, any questions? Okay, thank you. Minister, would you like to wind up?
Happy to move, Convener.
So the question is, Amendment 25 be agreed to. Are we all agreed?
Yes.
And I call Amendment 26 in the name of the Minister, already debated with Amendment number 25. Ask the Minister to move formally.
Move, Convener.
Thank you. And the question is, Amendment 26 be agreed to. Are we all agreed?
Yes.
I call Amendment 27 in the name of the Minister, already debated with Amendment 25. Ask the Minister to move formally.
Move, Convener.
Thank you. The question is, Amendment 27 be agreed to. Are we all agreed?
Yes.
The question is that Section 30 be agreed to. Are we all agreed?
Yes.
I call Amendment 28 in the name of the Minister, already debated with Amendment number 1. Ask the Minister to move formally.
Move, Convener.
Thank you. The question is that Amendment 28 be agreed to. Are we all agreed?
Yes.
And the question is that Section 31 be agreed to. Are we all agreed?
Yes.
I call Amendment 29 in the name of the Minister, already debated with Amendment number 25. Ask the Minister to move formally.
Move, Convener.
Okay. The question is that Amendment 29 be agreed to. Are we all agreed?
Yes.
The question is that Section 32 be agreed to. Are we all agreed?
Yes.
I call Amendment 30 in the name of the Minister, already debated with Amendment number 14. Ask the Minister to move formally.
Move formally, Convener.
The question is that Amendment 30 be agreed to. Are we all agreed?
Yes.
The question is that Section 33 be agreed to. Are we all agreed?
Yes.
I call Amendment 31 in the name of the Minister, already debated with Amendment number 14. Ask the Minister to move formally.
Move formally.
The question is that Amendment 31 be agreed to. Are we all agreed?
Yes.
And the question is that Section 34 be agreed to. Are we all agreed?
Yes.
Move on to Amendment number 32 in the name of the Minister, grouped with Amendment number 33. Ask the Minister to move Amendment 32 and speak to both amendments in the group.
Thank you, Convener. The committee's Stage 1 report considered the criteria a person must meet to be appointed as an accountant of court, concluding that what the bill provides for is sufficient. The committee did, however, recommend that the Scottish ministers periodically review the accountant's qualifications, and then they should have the flexibility to amend the qualification requirements by way of secondary legislation. Amendment 32 makes the recommended changes, and any regulations under this provision would be subject to the affirmative procedure. Section 36(2) of the bill imposes the same criteria on the person appointed as a depute accountant as those imposed on the person appointed as the accountant by Section 35(1). Therefore, Amendment 33 makes the same provision as to review the criteria as Amendment 32, but for the depute accountant. This ensures that both the accountants and the depute accountant's qualifications are subject to review and can be amended if needed. And Convener, I move both amendments in this group.
Thank you, Minister. Colleagues, any questions? Yeah. Minister, would you like to wind up?
No, just move, thank you.
Thank you. So the question is that Amendment 32 be agreed to. Are we all agreed?
Yes.
The question is that Section 35 be agreed to. Are we all agreed?
Yes.
I call Amendment 33 in the name of the Minister, already debated with Amendment number 32. Ask the Minister to move formally.
Move, Convener.
Thank you. The question is that Amendment 33 be agreed to. Are we all agreed?
Yes.
The question is that Section 36 be agreed to. Are we all agreed?
Yes.
And the question is that Section 37 be agreed to. Are we all agreed?
Yes.
I call Amendment 34 in the name of the Minister, grouped with Amendment number 35. Ask the Minister to move Amendment 34 and speak to both amendments in the group.
Thank you, Convener. Under sections 38(4)(b), if the judicial factor is a member of any professional body, the accountant is required to report any serious misconduct or material failure by the judicial factor to that professional body. The committee considered this provision in its Stage 1 report, and I indicated that I would bring forward an amendment so that the bill better reflects how complaints against members of certain professional bodies are currently handled. Amendments 34 and 35 make clear that where there are arrangements in place for another body to deal with complaints instead of the professional body, then the accountant must report the serious misconduct or material failure to that other body. For example, where the judicial factor is a solicitor, the effect of the amendment would be to require the referral of the accountant to be made to the Scottish Legal Complaints Commission rather than the Law Society. And I move amendments 34 and 35.
Thank you, Minister. Any colleagues? Any questions, colleagues? Okay. Minister, once again, thank you for listening to the recommendation from the committee with the Stage 1 report. So, Minister, would you like to wind up?
Happy to move.
Thank you. And the question is that Amendment 34 be agreed to. Are we all agreed?
Yes.
Call Amendment 35 in the name of the Minister, already debated with Amendment number 34. Ask the Minister to move formally.
Move, Convener.
Thank you. The question is that Amendment 35 be agreed to. Are we all agreed?
Yes.
The question is that Section 38 be agreed to. Are we all agreed?
Yes.
Call Amendment 36 in the name of the Minister, already debated with Amendment 16. Ask the Minister to move formally.
Move, Convener.
The question is Amendment 36 be agreed to. Are we all agreed?
Yes.
The question is that Section 39 be agreed to. Are we all agreed?
Yes.
The question is that Sections 40 to 42 be agreed to. Are we all agreed?
Yes.
I call Amendment 37 in the name of the Minister, already debated with Amendment number 14. Ask the Minister to move formally.
Move, Convener.
The question is that Amendment 37 be agreed to. Are we all agreed?
Yes.
And the question is that Section 43 be agreed to. Are we all agreed?
Yes.
The question is that Section 44 be agreed to. Are we all agreed?
Yes.
I call Amendment 38 in the name of the Minister, already debated with Amendment number 14. Ask the Minister to move formally.
Move, Convener.
The question is that Amendment 38 be agreed to. Are we all agreed?
Yes.
The question is that Section 45 be agreed to. Are we all agreed?
Yes.
The question is that Sections 46 to 49 be agreed to. Are we all agreed?
Yes.
And I call Amendments 39, 40, 41 and 42. Excuse me, all in the name of the Minister and all previously debated. Invite the Minister to move Amendments 39 to 42 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put to Amendments 39 to 42?
No.
The question is that Amendments 39 to 42 are agreed. Are we all agreed?
Yes.
The question is that Schedule number 2 be agreed to. Are we all agreed?
Yes.
The question is that Schedule number 3 be agreed to. Are we all agreed?
Yes.
The question is that Sections 50 to 52 be agreed to. Are we all agreed?
Yes.
And the question is that the long title will be agreed to. Are we all agreed?
Yes.
Thank you. And that ends Stage 2 consideration of the bill. So first I'd like to thank the Minister and their officials for her attendance today. And that does conclude the public part of the meeting this morning. And I'll allow the Minister and her officials to leave the room and then move the committee into private. So thank you very much.
Thank you.
And with that, I will move the committee into private. Thank you.